Recovering the Sociology of Law, Part 3, both in order to frame the sociology of law as a disciplinary specialty and to secure its place in the interdisciplinary law and society field. The sociology of law is to be judged first and foremost by the standards of its foundations in sociology. Sociology of law is always and necessarily sociology. It is from this basic insight that this book is written to explore the disciplinary focus of the sociology of law through a discussion of its theoretical orientations and substantive applications. Theoretical pluralism and substantive thematization are taken as a guide to bring out what is unique about the sociology of law as one specialty among several others in a discipline to which it must always relate, as well as with respect to other social science approaches to the study of law. These objectives are far from trivial for at least two reasons. First, within sociology, the sociology of law is in many ways still an underdeveloped specialty area, not in terms of the quality of its contributions, but in terms of its reception and status. The relative lack of attention to law in sociology can be seen, for instance, by the fairly recent institutionalization of the sociology of law in the American Sociological Association, where the specialty section Sociology of Law was founded only in 1993. Of course, internationally the cases vary. For example, the Polish section of the Sociology of Law was founded in 1962, the same year when the Research Committee on Sociology of Law in the International Sociological Association was established. But it is clear that sociologists of law still have to actively make the case towards their peers that their specialty too belongs to the discipline at large. Second, the retreat of the sociology of law away from the discipline into the law and society field has been detrimental to a proper understanding of what sociology can accomplish with regard to the analysis of law and what the relationship is and should be between socio-legal scholarship and sociological perspectives of law. Misunderstandings concerning the proper place and role of the sociology of law have tragically also affected its perception by sociologists in other areas of research. The reasons for this development are no doubt many, and also relate to the relative inability or unwillingness on the part of some sociologists of law to resist the pull of the law and society movement, brought about, at least in part, not by any intellectual considerations, but by the relative attractiveness of employment in law schools. In light of these realities, the ambitions of this study are at its most immodest, for this book is driven towards the objective that the sociology of law must once and for all reclaim its position as a uniquely useful approach relative to other disciplinary perspectives on law. An analysis of the sociology of law's most important accomplishments in theoretical and empirical respects may serve this aim.